SJC-11729, Commonwealth versus Broom.
Good morning, Ms. Caddick. Give us one moment, and then you can get started. Okay, please proceed.
All right. May it please the Court, Elizabeth Caddick for Eldrick Broom. I'd like to focus on today's argument on the lack of probable cause for obtaining both the cell site location information and probable cause to search the smartphone. There was no probable cause to obtain 31 days' worth of cell site location information. In the affidavit submitted in the application for the CSLI, the officer had stated facts involved on the day of the murder. Subsequent information from the statement of the defendant also would have given probable cause to obtain cell site location information for the evening before, since he had stated that he and the victim had been engaging in consensual sex at that time. However, without any explanation as to why 2 weeks before and 2 weeks after the crime, the CSLI was necessary, it simply asked for it and was given it. And the information was used against Mr. Broom at the trial.
But only 1 or 2 days worth, right?
Exactly. But you can't sever, as this court stated a few months ago in Estabrook, you can't, the Fourth Amendment, the violation and the 14th Amendment violation occurs at the time the search is completed. So the violation was when 31 days of CSLI was obtained. It doesn't matter how little of that 31 days is actually used at trial, and it doesn't matter that the time that was used at trial there was probable cause for, because the violation had already occurred.
Now, what is the consequence of there being no motion to suppress in this case?
There does not need to be a motion to suppress for a number of reasons. The main one is in Augustine 1, this court stated that Augustine 1 applies to cases that have not become final yet at the time the case was decided, as long as the issue was raised. I know the Commonwealth interprets that to mean it was raised at the trial court as opposed to raised before the case is final on appeal, but the court would have to have meant that, because the sentence before the court announced that this was this referred to cases that have not yet been finally decided. It said that no Massachusetts case even suggested that there was the requirement for probable cause or a search warrant for CSLI information.
But let's assume we accept that point, that it's on direct review and we'll hear it. If there had been a motion to suppress, the Commonwealth could have, either it may have been allowed, or the Commonwealth could have said, well, we don't need to deal with this aggravation, we'll just go get a search warrant for it. And there does appear to be probable cause in their 2703 application for the CSLI. So is it...
For the relevant days.
Well, that's another question.
Okay.
But we'll discuss, put that aside for a moment, but what do we do with the fact that because it was not raised below, the Commonwealth did not see any need to go back and get a search warrant for it, where they would probably have had PC at least for some period of CSLI?
Well, I think that question is answered. The Commonwealth did get a search warrant for the phone and did obtain the information that was the same as the CSLI on the phone, and there was no probable cause for that search either, because, again, the Commonwealth did not limit its request in searching the phone to the relevant times and relevant files in the phone. It asked and received permission to search the entire phone, everything on the phone, its entire history. So I would argue that even if the Commonwealth said, okay, we're going to go get a search. They already had a search, and it was faulty still.
I may have misread it. I didn't read that search warrant to seek CSLI. I know it sought everything inside the phone. Was CSLI within the scope of that search?
It didn't say CSLI. It did state that the specifics.
Did it include GPS or something?
It did not. It did not. It did contact information, data, internet browser. It didn't state CSLI.
So CSLI did not fall within the scope of that search warrant.
It doesn't look as if it did, but the argument is if it had done the search warrant, there's no reason to suspect it would have done it any differently than it did here. And the fact that the Commonwealth might have done it right if it was told that it had done it wrong, I don't know that any case has said, well, they could have done it right, so we're not going to find error. In this particular case, the court can look at the issue.
Well, of course, in Augustine, as I recall, Justice Botsford would know better. I think we gave the Commonwealth the opportunity to do a search warrant, and then we ultimately upheld
Correct.
that.
But you're saying they didn't seek a search warrant for this? Is that what you're saying, in part?
Excuse me?
That they did not, that the search warrant that was sought did
Right.
not cover CSLI? It covered the contents of the phone?
I'm seeing the quote from it. I don't see the CSLI or in here. In fact, they mention, in the search warrant application, they mention the CSLI, but they don't mention that they asked for it.
Of course, they already had it.
Right.
So let me follow up on that issue. So put aside your issue. Let's assume there was a search warrant which asked for 31 days, and let's assume we say, no, that is overbroad. You really should have asked only for the 10 days surrounding the killing. But all that's offered is within the scope of the 10 days within that. Do we suppress that which we said is permissible because we say the scope of the search warrant is overbroad?
If they had gone back, or I guess I'm confused.
I guess what I'm saying is, okay, let's assume for the sake of argument that we would say there was probable cause for them to get a search warrant for CSLI, okay? And let's assume that we accept your argument that maybe it was too far in time, that maybe it should have been a narrower scope in time, which is your argument, that
Yes.
it was overbroad. But I gather that the only thing that was admitted were the day before and the day of, which plainly would have been within the scope of an appropriate search warrant. Are we supposed to suppress that even though that would have been okay and would
Yes.
not have been the problem?
Yes, because in
Isn't that what happened
Estabrook.
in Estabrook?
Yes, because in Estabrook, that's what you said. It does not matter how little of the CSLI is used if the Fourth Amendment 14th violation occurs at the time of the search, not what's used at trials.
So what's the standard of review?
It's harmless beyond a reasonable doubt because this is a constitutional violation, and because of the clairvoyance factor, the trial attorney could not have been clairvoyant.
Well, obviously somebody was.
Well, that's true, but in Augustine 1, that came out 2 months after this trial, this court could only find, in its footnote 26, could only find 2 courts that, and they weren't appellate courts, 2 courts that stated that there has to be probable cause for CSLI information, and they were district courts in federal district courts in New York, the Second Circuit. So not only were they district courts, they were outside our circuit. They were not.
If we don't agree with you on the clairvoyance point, then what is the standard of review?
Well, then it would be a substantial likelihood of a miscarriage of justice, and I would say that there was, because his whole defense was that the sex was consensual the night before, and the CSLI information that was the most damning was the fact that at the time he said he was just leaving the victim's apartment after consensual sex, they had him a mile from his work at Boston Medical Center, about 6 miles from the victim's apartment, and the Commonwealth had already gotten out of him how he gets to work, how many buses he has to take, and how long it takes him to get from the apartments he lives in, which is also the...
But doesn't the victim's daughter also testify about, I mean, everything in this case, it seems to me, hinges on whether or not the jury believed that he was having consensual sex with this woman. Otherwise, his DNA was all over her.
Right.
And there was, so. But the daughter, who lived in this apparently somewhat small apartment with her mother and her disabled little brother, didn't she testify that she heard nothing, and so that there was basis other than this CSLI information for the conclusion that there had not been consensual sex?
Well, it was weak circumstantial evidence. It was, I didn't hear or see anything. So it wasn't direct evidence. It wasn't even strong circumstantial evidence. It was that I didn't hear anything, and his testimony was that it was a brief sexual encounter.
It's a little more than that. It's a very small apartment. She says, I always leave the door open.
Didn't they sleep in the same bedroom?
Yes, but this didn't happen in the bedroom, right? All the baby's crib and the 2 beds were in the same bedroom.
Did defense counsel argue the CSLI information for purposes of establishing an alibi?
For the day of the crime, there was CSLI information stating that he was near Clare Avenue. I believe that's in Dorchester, which is where his friend lived, and it was both in the morning and the afternoon, which is when he said he did visit his friend. So in that respect, it confirmed his alibi, but it was the problem.
And it was objective evidence that confirmed his alibi.
Well, for the day of the crime.
Wasn't that the thrust of it and the importance of it?
Right, for the day of the crime. But as I said, his defense was consensual sex. I mean, the defense had to remove the incriminating evidence of his DNA, and so the real damning evidence was that it negated his statement that he was having sex with her consensually the night before when he was somewhere else. So I would say that there is a substantial likelihood of a miscarriage of justice in that.
But what do we do when you say we have evidence which is inappropriately admitted, which is used by the Commonwealth to show, no, he was near Boston Medical Center at 9:58 p.m., so they're waiving it for that purpose, but you're waiving that evidence to say, no, you see, he was with Chico at Chico's house on Clare Avenue. So,
well, the fact that a defendant uses evidence that he would have rather kept out to his advantage doesn't mean that he's not harmed by other aspects of it, and doesn't mean he's waived any objection, or doesn't mean that then everything balances each other out.
Well, doesn't it suggest that counsel would not have filed a motion to suppress because he wanted the evidence?
No, he certainly would have filed a motion to suppress.
Do we have that? Is there a motion for new trial that establishes that?
No, but I think if you look at...
Can't we infer that counsel wanted this evidence?
No.
It was helpful. It was objective evidence that supported the defense,
No,
the defensive alibi.
Because what he also had, what Broom also had, was his fiance stating that during, between around 11 o'clock to noon, he was with her at their apartment. And so you have some other evidence that he wasn't at the victim's apartment at the time the crime may have occurred. The fact that there may be something positive, you have to look at what a reasonable criminal defense attorney would have done. I don't think you could say, oh, well, he let it in because it was a reasonable strategic decision. I don't think it was a reasonable strategic decision. What I think is that he didn't realize he had an issue because he wasn't clairvoyant. But even if he was clairvoyant, he would have filed a motion to suppress it, because the harm that came from admitting the CSLI overwhelmed the benefit that came from it. As far as the phone search, as the affidavit for, or I'm sorry, the application for the search warrant and the search warrant itself, in the wording, there is no limitation as to what the search should entail. It was for the whole phone, the whole history. It listed, emails, text messages, photos, chats, internet connections, everything. Now, it talked about, by then it knew of his confession, so it talked about where he stated he was the night before. It stated the cell site location information that they already had. And, it stated the murder and what it knew about his actions on the day of the murder. So, again, as with the CSLI, there's probable cause to look at information on the phone, the day before, the day of the murder, or anything that would explain the contacts.
Were there any time constraints on the search warrant?
There were none. There were none, and yet there was testimony that the victim had moved into the apartment buildings just a few months before. So I think there could have been, certainly probable cause to search for interactions between the victim and the defendant because he had said that they had this relationship, but even that would have been limited to the time when he would have met her.
Is there anything about the way the search was undertaken that's in the record?
No.
I mean, when they looked at the contents of the phone, is there anything about the way it was done so that there was a limitation of any kind put on it?
There's nothing in there, even though that was raised, even though the issue of probable cause and that the whole phone and the whole history of the phone was raised in the motion to suppress, the Commonwealth presented nothing at the suppression hearing to.
And remind me, Judge on that point, what did Judge Sanders say?
Well, what she said is she repeated what was in the affidavit, which was proof, what evidence they had that, of course, there was a murder and a rape, and what evidence they had that there was probable cause to believe it was Eldrick Broom. So there's that, and she repeated that, and then said, well, there could be information on, text messages, emails, call logs, photographs that give evidence of the crime, but nothing specific. It was not limited. And
But was it specific to calls between the defendant and the victim?
No, I mean, it mentioned what her phone number was, and that's one of the things that he wanted to look at, but it was not limited to just calls between the victim and the defendant, and certainly not limited to emails or text messages, because, as we know, the evidence that was admitted against him were text messages between him and his fiancée 3 days after the murder that were admitted as evidence against him. So I had argued that the magistrate who issued the warrant is offered no deference because, in fact, respectfully, it's argued that the magistrate did not do her job at looking at what should be narrowed in this search. It was a copy and paste from the application for a search warrant, including the words in the first person, the typographical errors. It was exactly the same thing, and it was just signed. And so
is it your argument that if a search warrant asks for 12 things and one of them is overbroad, that the entire search warrant is thrown out?
You're talking about a search of a phone?
Search of a phone. Let's assume that they asked for 12 things, 11 of them are fine, one is overbroad.
I would think it depends on what the one thing is. I mean, if you're talking about, say, emails, and that's the one thing that's overbroad, I think that's substantial, and I'd say yes.
Okay, but here, the one thing which you would think would be the strongest for probable cause would be text at or around the time of the crime, and that's all that was used.
Right, but again, you can't sever. I mean, this court, federal court says you can't sever what there was probable cause for from.
Okay, so
the-
so your view is that if it's overbroad,
Yes.
it all goes, even if that which was used was within the
Yes.
appropriate.
Exactly, and that's what the case law says.
And you think Estabrook says that?
Well, Estabrook, well, the,
Do you have any
my
cases, do you have any cases which say that in your brief?
I believe this court in Dorellis had.
Dorellis, it was, we said it was within, it was the photos,
Oh, I
which were claimed to
understand.
be overbroad,
Right.
and we said, no, that was within.
Right, and Dorellis doesn't apply to this case, because that was very different. But I'm just saying the concept that you can't sever, my memory is that that came from Dorellis, but it certainly comes from a Massachusetts SJC case, one of the many I was reading and preparing.
All right, thank you.
All right, thank you.
Good morning.
Good morning, and may it please the court, Kaylin Campbell on behalf of the Commonwealth. We ask you today to uphold the defendant's conviction for the murder of Rosana Camilo de Nunez. And before I start, I just want to note that this is a case in which there is overwhelming evidence of the defendant's guilt. There is overwhelming forensic evidence of the defendant's guilt. His sperm was found in both the victim's anus and vagina. It was found on stains of clothing that was underneath her clothing. His DNA could not be excluded from a sock that was used as a ligature around his neck. And the condition of her body, the way in which it lay, suggested that she was contemporaneously raped and murdered.
And the, so with respect to you talk about the sort of age of the sperms.
Sure.
But the defense was that they had had consensual sex actually on the day of the murder as well as the night before? Am
No,
I-
just the night before.
Just the night before.
And that
So-
was
So what's the timing, I mean, the age of the sperm?
the age of the sperm. The defense tried to put forward the fact that there were no sperm tails found in the sperm samples that were found, suggested that the sex had occurred earlier than the murder. However, we provided evidence from Kevin Koshurik from the BPD, who simply stated that you couldn't tell that from whether there were sperm tails available or not.
Okay.
So that was disproved. More than that, though, that whole defense was disproved by much of the evidence that the Commonwealth presented, primarily Navila Nunez's testimony, that she was awake until 10:30 that night with her mother, and the defendant alleged it was his specific testimony that his sexual encounter happened between 9:10, and it was over by 9:10 or 9:15. And Navila was still awake at that point. She hadn't even gone to bed. More than that, BPD took a light source, and it looked in the area where he had alleged to have engaged in the sexual encounter with the defendant and masturbated on her, and they didn't find any sperm in any of that area. So it was disproved by that evidence as well. But turning to the issues that my sister
Can I ask you a question? I know you're going to get there, but I think that it would be very helpful to me at least to know if we're talking about these CSLI violations or if there's a problem with the cell phone, the evidence that was gleaned from that and admitted at trial, what happens if that gets excluded? What does that do to your case?
I don't think it does anything, even if you were to apply harmless beyond a reasonable doubt, because it was a cornerstone of the defendant's defense. He mentions it in his opening, and he specifically mentions it in his closing.
What's the it in that sentence?
He mentions the
The CSLI was a cornerstone of his defense.
correct.
Okay.
Correct.
Mentioned because he mentions Clare Street.
He mentions Clare Street. But I would also disagree with my sister's characterizations of the CSLI from the night before the murder. This CSLI shows that his cell phone pinged off a tower that was a mile away from Boston Medical Center at 9:58 p.m. She claims that that was the time in which he alleged that he was engaging in the sexual encounter with the victim. That's simply not how the defendant testified. The defendant testified that he left the victim's apartment by 9:10 or 9:15. So it's certainly conceivable under that universe that he would be, I think it's 5 miles away or 6 miles away 48 minutes later under the most broad interpretation. So that certainly doesn't disprove anything that the defendant said. But if you look at specifically how defense counsel used it in his opening and his closing, specifically in his closing, he uses the Clare Street CSLI evidence to say, and my client's testimony is directly corroborated by this evidence. And so...
Now, with respect to the alibi defense.
Sure.
He did not have another human being who vouched for him in the alibi, did he?
He didn't. He did have Demetra Perkins, who was his girlfriend. She did testify that she did see him at certain points that morning. That
But no, I'm talking about at Clare Street, his friend's apartment.
No.
The friend wasn't there.
his friend wasn't there.
So the cell phone, the CSLI information, I take it, was the only evidence that corroborated his testimony that he had been on Clare Street twice that day.
Correct. And that's how defense counsel used it. But to go back to my sister's argument about Augustine, I simply don't think that it was intended to apply retroactively to cases where a motion to suppress wasn't raised. I don't think that's the plain language of Augustine. I don't think if you read the whole retroactivity section, it stands for that, especially based on the way that Augustine was litigated. The language says that it was only because the Commonwealth had consistently argued at the motion to suppress that the affidavit established probable cause that it would be applied retroactively to Mr. Augustine's case. More than that, though, I disagree with my sister's characterization that defense counsel would have to be clairvoyant to know that this was an issue. And I say that looking at the timing of this motion to suppress was filed in December 28th of 2012.
What motion to suppress? Are we talking in Augustine?
No, Mr. Broom's motion to suppress was
Didn't
filed.
raise the
Motion to
issue.
suppress
Did
the
not,
cell
did
phone.
not raise this issue.
Did not raise this issue. His motion to suppress was filed in December of 2012. Prior to that date, there is a Superior Court case, that Commonwealth v. Wyatt, which Justice Lowy authored, which was relied upon by Judge Sanders and Augustine. The date on that is August 2012. There was also another case, Commonwealth v. Tewolde, that
And Judge Locke had one, decided it the other way, right?
he
But
did. That was Williams.
in February or something?
That was February. Mr. Tewolde's motion to suppress was filed in September of 2012. There was a decision the other way, which was decided in November of 2012, and the Commonwealth's Rule 15 application had actually been allowed in January of 2013, which was before defendant's motion to suppress hearing in this case. So there was actually a pending appeals court case dealing with this exact issue at the time that the defendant's motion to suppress will allow. The Augustine case himself, the motion to suppress was filed in November of 2012, and his hearing on it was January 16th, 2013, so that again is before Mr. Broom's motion to suppress in this case, and Judge Sanders was the judge in both cases. CSLI was also specifically mentioned by defense counsel in the motion to suppress, but never mentioned in any way to say that it should be suppressed. So I would just suggest that this certainly was an issue that defense counsel knew about at the time. I would also note that most of those cases are just the cases I know about because I personally was involved with them, so that's not supposed to be in the entire universe of cases.
So that goes to the harmless beyond a reasonable doubt standard, but counsel is arguing that even if it was a substantial likelihood of miscarriage of justice, they meet that.
Yes, that goes,
Well, your first argument is you don't even get there.
you don't even get
And
there.
your second argument is about substantial likelihood is?
My second argument is if the court wants to view this somewhat as an ineffective assistance of counsel claim, he wouldn't meet the first prong because he wouldn't need to be clairvoyant at the time, because this certainly was an issue that there's a pending appeals court case. It was known. But even if you were to ignore that, I would say that the defendant hasn't shown that defense counsel's actions deprived him of an otherwise available substantial ground of defense, because the defendant used this evidence as the cornerstone of his defense. So it's simply, he would fail under both prongs. Now, moving on to the issue raised about the search of the cell phone. Justice Link, you asked a question about the record in this case and whether it revealed how this search warrant was executed. If you look at the actual search warrant itself, that wasn't challenged. The execution of the search warrant wasn't challenged. More than that, if you look at the motion transcript, specifically on page 47 of the motion transcript, the motion judge remarks to defense counsel, "It sounds like you're arguing this is a general warrant exceeding the scope of the search," and defense counsel disagrees with that characterization of her argument, and she simply then goes on to argue the nexus of the search warrant whether it established straight probable cause. So to the extent that my sister now raises claims concerning how this search warrant was executed, that simply wasn't raised below, and there simply isn't enough record support for this court to make any conclusions about the execution of this search warrant. And it's in that way that this case is different than Dorless, where it was raised and where the defendant did provide an expert and provide testimony about how these searches are conducted. And that's why it's really important in these type of cases with both the CSLI and the search of cell phones to look at precisely what the defendant raised. Because the Commonwealth, when the defendant doesn't raise the scope of the search warrant, it's not on notice that it has to provide evidence about how the search warrant was specifically executed. So that shouldn't be taken to mean that it wasn't executed properly or the defendant's constitutional rights were violated. It's just simply that the defendant didn't raise it at that time. But looking at the...
But I'm missing something.
Sure.
You're saying that he did not raise the issue below, that there was probable cause to search, or that the scope of the search was not properly confined.
Yes, where the execution, the way that the search warrant was executed exceeded the scope that was permissible.
And he didn't,
I thought-
and he didn't raise the general warrant point.
He didn't raise the general warrant point. The judge specifically said, it sounds like you're arguing that this is a general warrant, and defense counsel didn't agree with that characterization.
And there was nothing there about not being particularized enough?
I don't remember it.
Okay.
What did he raise below?
It was a nexus argument, that the items that they asked for, the Commonwealth didn't establish probable cause to show that they were connected to the crime. And when you look at the affidavit, it's our assertion that Judge Sanders did not err in finding that this nexus was established. While true that the affidavit lists a number of items, they can be broadly characterized into 3 categories. The first is communications, the second is identifying information, and the third I would characterize as other phone functions, but it simply seems to be what they asked for as internet browsing history. As to the third, they had specific information based on the defendant's phone records that he was browsing the internet at the time frame of the murder, which...
Nothing limiting the time frame in the search warrant. I mean, and I think the point's well taken, that even if it could be a broader category than the time, the days immediately surrounding the murder, to see what the relationship was. There's no evidence whatsoever, or nothing to suggest that they had any relationship until they moved into the building, until he and his girlfriend and their children moved into the building.
There is nothing...
It could have been limited at least to that period.
It could have.
And should have been.
I don't know if I can agree with that because, and this is where the difficulty comes in this type of cases and how cell phone searches are different than other types of searches. I'm not sure that that type of search can be done based on just...
You mean time limited?
Time limited, based on how information is stored on iPhones or how information is stored on smartphones.
That goes to the execution of the search, too. Of course it can be limited that way.
It does go to the execution of the search.
So when that's what's supposed to be sought, that's what's supposed to be looked for.
I understand that, Your Honor.
But I understood your sister to be saying that in terms of the time, was that you could only search for texts or cell phone, evidence of cell phone calls that had occurred within the period of time in which the relationship was alleged to have existed.
That is what she's arguing now, correct? That is
Yeah.
what she argued before you. And again,
And you're saying that would not be a proper argument because of the way information is stored in cell phones?
I'm just saying that I am hesitant to answer that question in certain ways just because I don't know what the technology is. And from...
Okay, supposing all the cell phone calls are stored instead of chronologically, he can put them someplace. Instead of storing them chronologically, he stores them alphabetically by whoever the other
name.
caller is or other speaker is. You're saying that they can't go through the whole alphabetical list and only open the ones that are within a certain period of time, within the time range. You just skim over the ones that you can't open the ones that are listed alphabetically unless they are
Unless you have probable cause to believe that they're connected to the crime.
that they're made within that period of time.
Correct. Under your hypothetical, I'm not sure, would there also be information as to the
As to the
time
time,
frame?
in addition to the alphabetical reference. Okay, I see what you're saying.
And I don't know how these items are currently stored, and because there is no record of this, I don't think I can give an answer to the question as if it was.
So if they're only stored alphabetically, you would be entitled to look in them to see if the call was made within the desired time period. If it wasn't, you couldn't go any further. If it was within the appropriate time period, then you could proceed.
I believe that would be a fair. I believe that would be a fair reading. The record doesn't reveal, and I just don't know how exactly this data is stored, and that's sort of the problem inherent in a lot of these cases, is that it's different insofar as the way that they get the information. It's different insofar as every cell phone stores and keeps information in different ways. So it's really a complex. Every single search presents the court with a complex set of circumstances that doesn't necessarily fit into the traditional search and seizure type of framework.
And if we were to find it overbroad, what do you contend is the remedy?
If you were to find it overbroad, I think you would treat it just the same as you would treat a search warrant for a house, and you would excise the parts that you didn't have probable cause for.
And see if they were used.
And see if they were used at trial.
And if we did that, what's your argument here?
If you did that, and even if you didn't do that, even if you were to suppress everything, I still think that the omission of this evidence was harmless beyond a reasonable doubt because it was just so limited. At trial, there were...
That was the thing that came in, I gather, which was of most consequence, is the text of the girlfriend about complaining that because she was 9 months pregnant, he was sex deprived.
Yes, but that came in only solely to impeach the defendant's testimony. When you look at how...
And wasn't that testimony brought up on cross-examination in any event? Did the question being asked whether he was sexually frustrated?
I believe the defendant opened the door by his direct examination, the way that he testified on direct examination. Specifically, if you look at transcript 10, pages 94 through 95, he testified on direct that he and his girlfriend couldn't have sex at that time because she was 9 months pregnant, but he also testified that he was reconciling with his girlfriend because of previous infidelities at the time of the murder. And then he went on to testify and present himself as a family type of man and to present the relationship in a positive light. I would say that opens the door to being impeached, at least as Judge Locke saw it. He said, sure, you can ask him the question, were you sexually frustrated? If he says yes, that's all you can get. If he says no, then you can impeach him with this statement.
And go ahead.
Was there, when that happened, did Judge Locke give a limiting instruction?
He did not give a limiting instruction immediately, but there was a limiting instruction in the final instruction.
Did the defendant's girlfriend herself testify in this case?
She did.
And she testified to this discussion about sexual frustration?
She did not.
Okay.
She did not. It was only after the defendant went on the stand and testified on direct about reconciling, painting himself as this family man.
But some of the text messages that were introduced were used to refresh her recollection?
Correct, about timing. There was a specific one just about her timing. She had gone grocery shopping earlier in the day, and she couldn't remember what time she had gone there.
But that was the focus of when they were together that day, right?
Correct,
Yeah.
correct.
So they went in evidence as opposed to just refreshed her recollection?
They did not go into evidence.
They did not?
No.
Oh, okay.
They just refreshed her recollection. And that was cumulative. The prosecutor could have done that with the phone records themselves, which showed that text messages were sent between the two at certain times. Those were admitted substantively into evidence. But the content wasn't.
And what do we do about the juror note not being shown to defense counsel?
Sure. As to the juror note, what the judge did was proper, but even if it wasn't, I would turn the court to Commonwealth v. Curtis, which I cite in my brief, but the site is 417 Mass 636. In that case, the court held that where the instruction itself is proper, any constitutional violation that occurred from the lack of the defendant's opportunity to craft that instruction is harmless beyond a reasonable doubt.
Did the judge, I just can't remember the timing, when Judge Locke ultimately read the note, that was after he had given the instruction, is that right?
When he read the note to counsel?
Yeah.
Yes, it was after he gave the instruction.
And what was Mr. Zalkind's response to that?
His response to that was, he moved for a mistrial, and then he said, well, if I had known the content of the note, I would have asked that you not instruct the jury that a note had been written. But the fact that a note had been written, Judge Locke had told the counsel beforehand that he was going to instruct as to that. So none of the objections that defense counsel ultimately raised.
Well, but in fairness, Mr. Zalkind wasn't able to make the argument when the judge said, I'm going to do this, right?
He could have objected to an instruction being
But
given.
Well, my only point is, if he didn't, I assume that his point that I would have asked you not to say anything about it was because of the contents of the note.
I think that's a fair assumption. I don't think, though, absent, and the defendant doesn't argue this on appeal, absent of finding that Judge Locke's instruction itself was erroneous, then the defendant can't be found to be prejudiced by the instruction.
So even if it were error not to share the contents of the note with counsel, you're saying it was harmless?
Correct.
All right, thank you.
Thank you.